The Texas Heartbeat Act is bringing out all of the toddler politicians who want to distract from their own disastrous management of their own cities, like Portland's Mayor Ted Wheeler. Jenna Ellis is an attorney and former senior legal advisor and counsel to former President Trump. She joins us now to discuss this new law and the virtue signaling coming from all of these other Democrat officials. This was about right to privacy, never about establishing taxpayer-funded abortion on demand. Talk to folks a little bit about that if you can.
Yeah, well, of course, the leftist talking point is that the Constitution somehow provides a right to abortion access. That's not at all what the U.S. Constitution says. In fact, we don't get our rights from the Constitution. Our Declaration acknowledges that we get our rights from God, our Creator, and it's the sole purpose of government to preserve and protect those rights. And so the Constitution simply lays out very specific, limited, enumerated powers for the federal government. And then our 9th and 10th Amendment expressly says that whatever powers are not specifically granted to the federal government are reserved to the states or to the people. And so not only do we have a separation of powers to make sure that we don't have an overbroad runaway government that's tyrannical, we also have the specific limited enumerated powers. And so when we talk about this right, so-called right to abortion access, not only is that completely not within the context of the Constitution, but it's also actually intentionally misinterpreting Roe versus Wade, which simply held that the government does have a compelling interest in protecting life, but under the auspices of a so-called right to privacy in abortion decision-making, women can access some abortions in some circumstances. Now, Dana, I firmly believe that with the technology that we have today, with all of the pro-life understanding, when life begins, heartbeat, fetal heartbeat, all of these things that we know, trust the science, right? If the same Supreme Court in 1973 heard that same case, Roe would have been decided far differently. And I think the restrictions on abortion would have been limited even more than the Roe court held.
And you make a good point talking to Jenna Ellis, who has she is an attorney, and what you sound like there is exactly what most of my lawyer friends sound like. They think that they've always thought that Roe v. Wade, even those who are kind of in favor of it, who are a little bit more moderate Democrats, they have always thought that it was a garbage case. It was not well approached. It was not well argued, and that the reasoning was flawed. Which I've always found kind of fascinating. And you're shaking your head. You're like, oh yes, it is.
Yeah, absolutely. And it started actually back in 1965 with a case called Griswold versus Connecticut, which basically that was one of the first cases that dealt with this so-called right to privacy, which read into the Constitution to find under what they called the vast penumbra of the Constitution that certain rights emanate from the Constitution that aren't expressly defined. So this allowed the Supreme Court to have so much wiggle room as a standard to say, well, things that aren't expressly granted to government as a power, we're just going to read into the Constitution whatever we want. And so all of the line of precedent that has been progressive era regulations and opinions have come from that 1965 case, which was absolutely a terrible opinion. And it was completely legally unjustified, unconstitutional. But when we get to things like Roe versus Wade, its progeny, Planned Parenthood versus Casey, even things like the Obergefell decision that legalized same-sex marriage, which of course the federal government doesn't have marriage licenses. That should be up to the state. So when we get to all of those opinions, as well as future Supreme Court decisions, we can find that the Supreme Court started to get off track when it tried to just read into a document that very plainly says, hey, you are limited government in the power that you have.
And it seems too, Jenna, that the reaction to this by the left, like Portland saying that they're going to ban traveler trade with Texas, and I'm just thinking, okay, well, maybe we can do that in reverse, like an exchange with oil and gas from Texas, going to Portland. No more pine cones for us, I guess. That'll work. But when I see the way that the left reacts to this, it really does seem like they're trying to use this as some kind of another get out the vote apparatus, because Biden is, tanking in approval. I just saw another poll that came out today that showed if Trump and Biden were in a matchup right now, Biden's going to lose that. I think even Newsweek wrote about it, which kind of shocked me. And I didn't look at the crosstabs of the breakdown of that poll, but I'm like, yeah, I can imagine, because people are they're having to go all in just to save Newsom in California, for crying out loud. But the reaction to this, using it not only as a get out the vote apparatus, but also twofold. I really see a lot of people using this to justify packing the court, Jenna, and they're unhappy because they say it's a conservative dominated court, which I still think is a weird characterization considering some of the rulings of some of these justices previously. Your thoughts?
Yeah, well, of course, the Democrats are trying to use this as an opportunity to pack the court. And, listen, this is another thing. They didn't want to pack the court when they had an activist majority. And so, of course, there should be a conservative majority. And by that, of course, we who are originalists, who understand the rule of law and the actual role of the judicial branch, which is simply to make sure to keep the other political branches in check. We want a conservative majority, not because that means that Republicans will win all the time, but that the judicial branch will function according to its constitutional purpose. And that's what the Democrats don't want. They want a rubber stamp on all of their horrendous, unconstitutional, petty tyranny policies, and they don't want a Supreme Court that will actually keep them in check. And so court packing is just their latest attempt to say, hey, when we're actually held responsible for our actions and held in accordance with the Constitution, we'll try to find another loophole and get our way. And that is where no one in their right mind would ever vote Democrat again if they actually care about fundamental freedoms and liberties. And we can all disagree on policy. We can disagree on a lot of different things. Sure. But we should, as Americans, like our founders did, unanimously agree on our charter, which says that we as individuals can make the best decisions for ourselves in the area of individual freedom and liberty. And no government should have the power or harness the power to do things like compulsory vaccinations, like saying you have to have all of these waiting periods to exercise your Second Amendment rights, like what Gavin Newsom has been doing in California, wanting to shut down churches and say you can't exercise religious freedom indoors in your church. Meanwhile, strip clubs and other types of businesses that he condones are perfectly fine to be open amid this pandemic. I mean, we've seen hypocrisy after hypocrisy after hypocrisy coming from the Democratic left, not only from Washington, but all throughout the states that are Democrat controlled.
It's going to be fascinating to watch what happens in midterms. I don't know if I've ever been more excited about upcoming polling, because normally I think everybody kind of lost faith in it, but now it seems like people are trying to beat each other out of the gate with getting it to be at least somewhat more accurate. I can't wait to see what happens in midterms. It's going to be like the shellacking in 2010. We got to have you back, Jenna Ellis. So good to talk with you. Thanks so much for joining us today.